Yes, Your Honor. I'd like to reserve 5 minutes for rebuttal.
5 minutes, yes, sir.
My name is Gregory Isaacs, and I represent the appellant, Mr. Newman. The issues that we've raised, I'd like to briefly review the facts to put them in context because it's a factual-driven argument. April 11, 2020, Saturday afternoon outside of Oak Ridge, Tennessee, a neighbor, Mr. Arms, hears a loud noise next door. He looks out at the adjoining house. His view was from the perspective of being approximately 200 feet away and through a canopy of trees. Mr. Arms testified that he saw an individual with tattoos carrying a box. He said the individual made eye contact with him, walked around the corner of the house, and subsequently made his way to the Raceway convenience store. There are significant parallel facts. Christina Perdue testified that she had dropped off Mr. Newman in this same area a few minutes earlier to look for his cell phone. Christina Perdue was a licensed clinical social worker that worked for Summit Medical Group. She was engaged to Mr. Newman. She indicated that they were both there looking for the phone because she had Googled Find My Phone on her phone, and it was indicating it was in the area. She shows up to the Raceway as the neighbor, Mr. Arms, is following someone to the Raceway. And Mr. Newman is there, and this is a significant fact, talking to someone in a black truck. And during the trial, the state's theory was that the individual in the black truck was complicit in Mr. Newman's criminal conduct. Mr. Newman, as the record reflects, borrowed the individual's cell phone to contact his fiancée, Christina Perdue. She arrived in a red Kia with chrome wheels. Mr. Newman gives the phone back to the individual in the black truck. Around the corner comes Mr. Arms. Mr. Newman gets in the vehicle with Ms. Perdue, his fiancée, and they leave. She is somewhat concerned that she is being followed by a white Hummer. She continues on her way home to Oak Ridge, where she is eventually pulled over by the police. They come in hot with guns, get out of the car. What is significant, the record shows, that when the person that Mr. Arms said was Mr. Newman went around the house carrying a box of apparently stolen property, the box was never found. The record reflects that Mr. Arms called 911 and said he saw two individuals leave this residence at 4 in the afternoon on a Saturday. He also felt that the black truck was complicit in this and that he'd seen the black truck a few days before. After the state rested, we were able to subsequently track down the driver of the black truck via the cell phone, and it was an off-duty Anderson County police officer, reserve officer, that worked in security for Covenant Health. He had simply given Mr. Newman his phone to use, as Mr. Newman had lost his phone, as he'd done over a dozen times before, according to Ms. Perdue. So you have a huge mistaken identity situation. Mr. Arms, in his white Hummer, followed Ms. Perdue. He was instructed by 911 dispatch to cease and desist. Then they were arrested. So those facts in that context is very important. This series of events began with Mr. Arms calling 911, saying there were two people breaking in a house, saying there was a box. None of those facts were accurate or came to fruition. In fact, the man in the black truck that they thought was secreting stolen goods was an off-duty Anderson County reserve officer. Subsequently, when they were pulled over, Officer Thomas searched the vehicle. He removed a gray shirt jacket and placed it on the hood of the car where he saw glass shards. Significantly, There was no stolen property, the record reflects, in the red Kia. No evidence or indicia of any illegal conduct, but for a few glass shards. We strenuously objected, had a hearing outside the presence of the jury under this issue, and that's one of our first preliminary issues.
Well, let me interrupt you one moment. I could not find in the record where you objected and what ground you stated as your ground to object. Can you tell me where that is?
If I can have just a moment,
Sure,
Judge Ward.
Sure. It's customary, if you have made an objection, to place that in your brief with a citation to the record where that can be found.
Yes,
to
yes, Your
assist
Honor.
us. Well, I don't mean to interrupt you. If you can't find it,
If I can reserve that to my
problem.
rebuttal time.
Please continue with your argument.
Well, I had a question about the glass too. So you, let's assume you objected correctly to the glass shard evidence coming in. Was there a window broken or glass door broken in the burglary?
Judge Wilson, there was testimony that some French doors had been broken at the scene of the burglary.
Okay, so tell me, even though it's not the strongest evidence, I think you raised that it wasn't tested, tell me why you don't think that tends to prove a fact at issue.
Well, our argument was basically a 401 and 403 analysis, and our position was it did not tend to make a fact of consequence more or less probable in conjunction with the fact that there was no other evidence found in the red Kia that linked Mr. Newman to the crime scene. And it was just random shards of glass that was observed by Officer Thomas on the roadway on top of the red Kia when he had removed the jacket and placed it on top of the vehicle.
All right. So, and also the 403, that's, you're saying that, how's it prejudicial if it doesn't prove anything?
Assuming, again, it's our theory this was a case of mistaken identity where Mr. Arms made the wrong identification and his observations and then subsequently pursuit of Mr. Newman and Ms. Perdue is what alerted law enforcement. But for the glass shards, there would have been no evidence, not a scintilla of evidence other than that flawed eyewitness identification by Arms 200 feet away through a canopy of trees.
Is part of your position that the flawed identity of the defendant take into account that he was wearing clothing that matched the description, correct?
Well,
was there any dispute about that? The gray jacket seemed like red shorts or?
Some shorts, and Mr. Arms very vividly indicated that he was carrying a box, pulled his pants up, walked around the corner of the home. But there was also testimony in the record that he had seen an individual with similar tattoos walking up and down the roadway frequently. Now, interestingly, the testimony from Ms. Perdue was they did not live in that area, that they traveled through Solway typically on a daily basis on their way to their residence in Oak Ridge. Now, the next issue that we would like to address is the issue of the flight instruction pursuant to TPI Pattern Jury Instruction 4218. And we think this is significantly material in this case because the facts show that Mr. Newman and Ms. Perdue were there looking for his cell phone. Ms. Purdue, a licensed clinical social worker, indicated that they were in that area because the Google app Find My Phone took them to that zone. And they were minding their own business. Mr. Newman, the record reflects, was talking to the man in the black truck, a Oak Ridge Reserve officer, to use his phone. He gets in Ms. Purdue's red Kia, and they drive off, and suddenly they are chased by Mr. Arms. They did not avoid law enforcement. They did not flee a crime scene, but they were being pursued by Mr. Arms. Curiously, when they're pulled over, when the blue lights are activated, the record reflects that Ms. Purdue stopped her car immediately, was polite, and they were met with a number of officers with drawn weapons. We would cite the court to the Martinez decision, also State versus Wittenmeyer, which we think is probative. In this case, they left the Raceway Market, which not a crime scene, with no evidence whatsoever, with the exception of the glass shards, and did not secret themselves, did not evade law enforcement. Once blue lights were activated, they were very compliant, stopped right away. So it is our position that for the court to allow the jury instruction for 42.18 was error in this matter. The other matter.
Excuse me, counsel. I want to make sure I understand your argument, because at the trial you said that you objected to this instruction being given because, quote, he wasn't being pursued by law enforcement, he was getting chased by Mr. Arms, end quote.
Yes, sir.
So is your argument that it's inappropriate to give the flight instruction if you're fleeing from a private citizen, or it's that there was no flight at all, or I just want to make sure I understand, because the words you used at the trial was he was being chased by a private citizen.
That was the totality of the argument under Wittenmeyer and Martinez. I mean, what we were saying was basically they had not committed a crime, but nevertheless were being pursued by a private individual for reasons that neither Ms. Purdue or Mr. Newman understood. So I think it's important for the two-pronged test as to, one, why they left the scene, and second, did they seek to evade, hide, or conceal themselves from law enforcement? Because when you juxtapose being followed by the white Hummer, which was Mr. Arms, and Ms. Purdue's conduct of immediately stopping her vehicle when the blue lights were activated, I think that clearly negates the second prong of what would be required for the flight instruction.
Okay. Thank you.
The last argument we would address, well, there's two. One is the mistrial issue with Judge Green. The jury was out over 7 hours in this case. The day before, we indicated that if the jury had problems reaching a verdict, that we would accept a hung jury. We put that on the record. We felt that was important with the way deliberations were going. The following day, we were summoned into chambers. We had no idea the reason for being summoned. And Judge Green read a note. In retrospect, I would have probably had a court reporter there, but I didn't know if we were scheduling lunch. Judge Green has a fairly open-door chambers policy during the course of a trial. There was a note that's reflected in our brief that the jury was concerned they were deadlocked on one of the counts and wanted to know what to do to avoid a hung jury. I wanted to put that on the record and make a motion. Judge said, I will bring the jury in and do that, Mr. Isaacs. Time drug on. He does summon the jury back in and tells them that there's a Christmas parade at a few hours at 3 o'clock. 40 minutes later, they come back with a verdict. We then immediately put on the record our motion for a mistrial based on the note, and also asked the judge to serve as a 13th juror, and overturn the verdict. So we would submit that it was error under Gilley and State versus Husky not to have granted a mistrial under those circumstances, and that we would respectfully say that it wasn't waived. I see that I'm out of time, so I will.
Just one question on
Sure.
that. At what point in the progression, it was in one of the briefs, did the trial court tell the jury, you got to rely on the instructions I already gave you? Wasn't there a direction at some point?
There was, when we thought we were coming back in, basically to put the response to the note on there about 3 hours later and make the motion. That's my understanding of how the record reflected Judge Green's comment on how they were to handle further deliberations.
So that was before he called him in and told him about the Christmas parade?
It was contemporaneously.
Okay, thank you.
All right, thank you. Ms. Reddick?
May it please the court, Catherine Redding on behalf of the state. The trial court acted within its discretion when it admitted the evidence of the glass shards. And I think before actually I get into that, the defendant has given his version of events, but I'd like to present all of the facts that came out at trial because I think it's important to understand exactly what happened here. So the defendant's correct. Mr. Arms was outside with his family when he heard a loud crash and a racket coming from his next door neighbor, Amanda Lane's home. He was surprised by the noise because she wasn't there. There were no cars in her driveway. So he approached the house to see what was happening and saw a man who was wearing red pants, a gray jacket, black hat, and black shoes in Miss Lane's breezeway walking out of her house, out of her front door. The man was carrying a box. When the man saw Mr. Arms, he slowly walked around the corner of Miss Lane's house towards the nearby trees. Mr. Arms had his wife contact Miss Lane to make sure she wasn't moving, she wasn't expecting anybody, and Miss Lane advised she was not moving and nobody was supposed to be there. So upon learning that the house was supposed to be empty, Mr. Arms got into his vehicle, drove out onto the main road. He eventually went to the raceway, which was located. Miss Lane's property is here. There's a map in the as one of the exhibits, but Miss Lane's property is here. There are trees, and then on the other side of the trees is the Raceway gas station. So Mr. Arms eventually went to the Raceway gas station, and he saw the man in red pants, gray jacket, black hat, black shoes. The man no longer had a box, but he was standing by a black pickup truck. When that man saw Mr. Arms, he became, quote, panicky acting. Mr. Arms pulled behind this black truck. The defendant began cursing at Mr. Arms and threatening him. The black truck drove off. Mr. Arms calls 911, describes the defendant, and conveys the events that occurred at Miss Lane's home, at the gas station. So the defendant, who Mr. Arms testified was on his phone, walked inside the gas station, and then immediately came back out and jumped into a red Kia with chrome wheels, driven by a woman wearing blue scrubs. Mr. Arms remained on the phone with 911. He followed the Kia, provided a description of the vehicle to dispatch. Eventually, the police told him, well, we have a perimeter. You don't need to follow them anymore. So an officer positioned himself on the vehicle's likely route, saw a red Kia matching the description drive by. The license plate was 1 digit off from the license plate Mr. Arms had provided. He followed the Kia, conducted a traffic stop, found and detained the occupants, which were a woman wearing a blue scrubs and the defendant. The officers searched the Kia and placed some of the contents on the hood of the car, and one of those objects was a gray jacket with a black liner. And as Officer Thomas watched the search, he noticed bits of glass on that jacket and then on the Kia and on the ground.
Did Mr. Arms show up at the stop?
Yes, he was on his way home and he got a phone call, and the officers asked him to come make an identification, and he went and identified the defendant as the man.
He identified the defendant as the man he saw in the breezeway.
Yes, and I believe his testimony was based partly on his clothing. I mean, the defendant was wearing red pants, which are not terribly common, but not unusual. But they were distinctive enough that Mr. Arms recognized.
Depends on your taste in pants, if you like red pants.
Yeah,
right?
Red pants are great.
But did he also identify the defendant in front of the jury at trial?
Yes, That is my recollection. And so it's after Mr. Arms, or possibly simultaneously, while Mr. Arms is identifying the defendant, Ms. Lane gets to her home. She finds that her main door is broken, the glass in her interior French doors, the glass is broken, as are some televisions, and that her clothing and some of her belongings are missing. And so then Mr. Arms gets home and he finds a path through the mud that leads from the house to the gas station, and finds a few of Miss Lane's missing purses in the trees along that path. So those are the facts. And it's the state's position that the trial court acted within its discretion when it admitted the glass shards because it was relevant, which the defendant did object. He did object to the line of questioning related to the glass shards. I don't have the record in front of me. My recollection is that it was not.
On page 95, he said, "Your Honor, I would object since this officer is not the one that did the search."
Yes, and I also have a note in my, and the record will speak for itself, but I also have a note in my brief that says on volume 3, page 82, he objected to the line of questioning related to the glass shards. And my recollection is that there was no relevance. Relevance was not identified as the ground. No specific ground was identified, but certainly in the motion for new trial, relevance is the ground.
Didn't they have a jury out hearing immediately after that?
The testimony occurred at a jury out hearing. The court held a jury out hearing to hear what Officer Thomas had to say, and after it ruled, then Officer Thomas was allowed to testify about the glass shards. But it's the state's position that the glass shards are relevant because they tend to prove the defendant's identity as the individual who unlawfully entered the victim's residence, damaged her property, and took her belongings. So we have evidence that shows that the glass in the front doors was broken, and that the defendant was wearing a gray jacket both when he left the victim's residence and when he was at the gas station. Officer Thomas's testimony that he saw glass shards on a gray jacket found inside Miss Perdue's vehicle at the time of the arrest, which occurred shortly after the incident at Miss Lane's home, made it more probable that the defendant committed the charged offenses, because it tended to show he was inside the residence and that he broke the glass in the French door. And even if this evidence was prejudicial, there's no basis to find that it's unfairly prejudicial. And even if the admission of the testimony was error, it was harmless because the defendant bears the burden here, and he cannot show that it more probably than not affected the verdict. And that is because Officer Thomas's testimony about this was very limited in scope, and it was unlikely to inflame the jury and prejudice his defense, especially given the rest of the proof. The glass shards were really fairly minimal. So the defendant is not entitled to relief on this claim. As to...
I want to hear from you on how the hung jury situation was handled.
Sure. The state's position the defendant is only entitled to plain error review because he waived plenary review by failing to take reasonable action here. So in the defendant's brief, he raises two claims. He's claiming that the trial court erred by failing to conduct a hearing after it received the jury's note, but it's the state's position that he's waived plenary review of this because he could have asked, when the jury did not show up in the courtroom, he could have asked the court to bring them in to conduct this hearing, but he failed to do so. And even if he thought that it was unnecessary, there's some indication that he didn't request a hearing because he thought the court was going to do it on its own. But he's argued here this morning that the court told the parties in chambers, it sounds like, that, well, okay, we'll go back in the courtroom and put it on the record, and that did not happen. Is there anything in the record that would indicate that's not the way it went down? No, there's nothing in the record, period, about what happened other than the trial court's recollection. So we don't have a transcript of what happened. It's the state's position that it's waived because the defendant could have asked for a hearing, could have, if the court said it was going to have a hearing, could have said, hey, Judge, you said we're going to have a hearing. Where's our hearing?
But we do have a transcript of what happened when they came back into court. Is
We
that
do,
correct?
yes.
What happened when they came back into court? the next
So,
time?
I guess what I'll say is that we know on the first day of deliberations that the jury did not return a verdict. And we have this discussion about, well, it's kind of the end of the day, let's bring them in and see what's going on. And that's when he says, well, we'll either see if they're close to a verdict. If they're not, we'll come back. If they say that they're hung, do you have any objection to a mistrial? The defendant says no, like that's, if they're hung, we'll have a mistrial.
All of that's
That's it.
pre-note. That's
Yes.
before the note came.
Yes.
Okay.
And then the next thing we have in the record is after the note has arrived, after the response has gone out, we have no information about when that note came in. We have no information about, apparently there was a discussion. The discussion's not in the record. We have the note and we have the response, but we don't have anything about when it showed up or what the circumstances were or how the parties agreed or what they agreed upon on how to deal with the note. Certainly nothing about a hearing.
Does the record indicate how much time passed between that discussion that there's no record of and the verdict? Mr. Isaac said something about 3 hours, I think. About 3 hours later, they're back in the courtroom.
So my recollection is that the motion for new trial hearing, the defense counsel says the note arrived around 11 o'clock. But that's not in a transcript from,
That's his argument.
that's his argument. I want to make sure I'm getting this right, so. Yep. So we do know that the jury returned at 9 a.m. We know that the jury sent out the question and the court sent a response. We don't know when the question arrived. We don't know when the response was sent back. The first thing that shows up in the transcript from day 2 is the court saying, let's bring the jurors in to take their temperature, and we'll tell them that there's no shame if they can't reach a verdict. But that's after the note, and I don't know how much
But then
longer.
he eventually brought them back in. What did he tell them when he brought them back in?
My recollection is that he asked, I'm not sure.
Mr. Isaac indicated that he sent them back out to deliberate further.
Yes, and that is clear. I don't recall the exact words that the court used when they brought it in, but it is clear that the court had a discussion with the parties, but let's bring them back in, they'll see what's going on. And then the jury came in and he advised them that there was no shame if they couldn't reach a unanimous verdict, which was consistent with his discussions with the parties. And the jury went back out to continue deliberating.
Does that record from that point on show any objection by Mr. Isaac?
No. My recollection is that when the jury comes in, the foreman indicates that further deliberations would be beneficial. There's no indication that they are actually hung. Even the note itself, and I guess that's the point too, is that the jury's note says, we have not reached consensus on count 1. We request further guidance per the instructions to prevent a hung jury. So the defendant's claim is that the trial court, that there's plain error because the trial court breached a clear and unequivocal rule of law by not declaring a mistrial. But he can't establish what happened. He cannot clearly establish what happened. We have some indications, but it's the state's position that that's not enough. He can't show that the waiver of this issue, because it is clear that the defendant waited until after the jury returned its verdict to request a mistrial. And he can't show that waiting to request a mistrial was not a tactical decision, because what we have here, we have information about how long the jury has been out. The jury has been out for 9 hours. The note indicates that they are having trouble reaching a verdict. It does not indicate that they are hung. It does not indicate they're deadlocked, irrevocably deadlocked. The note indicates that they are struggling. So based off of this, the defendant can't show that it wasn't a tactical decision not to inquire.
Did the trial judge respond to the note with some sort of written response?
Yes, he said
Is
you
that
must.
in the record?
Yes, he said you must rely on the instructions given.
Right. Go back and read the instructions you already have.
Yes,
But he wrote that out, and that was taken back to the jury.
yes.
Okay.
And there's no follow-up from the jury. The next thing that happens is the court say, well, let's bring him in, see what's going on. But it's the state's position the defendant can't prove that it wasn't a tactical decision. I mean, when a jury is out for 9 hours and they've indicated that they're struggling but not deadlocked, defendant may choose to let it ride. Maybe he's going to be acquitted. Maybe he'll be found guilty of a lesser included offense. But certainly, certainly the defendant can't show the breach of a clear and unequivocal rule of law, because by failing to conduct an inquiry in the morning and by failing to declare a mistrial, given what the note says. The note only says we haven't reached a consensus. We want more guidance per the instructions on how to avoid a hung jury. It doesn't indicate the jury is actually deadlocked. So the court didn't breach a clear and unequivocal rule of law by failing to inquire into its progress. And even if it had indicated it was deadlocked, the mistrial is down the road. There are things that the court could have done in between then. The defendant has to show manifest necessity for a mistrial, and certainly this note does not require the declaration of a mistrial such that failure to declare a mistrial is the breach of a clear and unequivocal rule of law. And I'll just, in my time that's remaining, unless the court has further questions on the mistrial issue, I'll just briefly touch on the flight instruction. So the state's position that the trial court properly instructed the jury on flight because the record does contain substantial evidence to support the instruction. The defendant left the scene of the difficulty when he left Miss Lane's property after Mr. Arms observed him. He engaged in a subsequent hiding out or evasion when he entered the woods to avoid Mr. Arms. He went to the gas station, then he got into Miss Purdue's vehicle, and he left the area. But even if the court erred in instructing the jury on flight, the error is not reversible. The trial court instructed the jury that whether the defendant fled was for its determination, that it didn't have to infer flight, and that flight alone is insufficient to prove guilt. And the jury's verdict here did not turn on flight because there was other evidence of the defendant's guilt. I mean, Mr. Arms testified clearly that he heard the large crash, the racket, coming from Miss Lane's home when it was supposed to be empty. He saw the defendant, who was unknown to Miss Lane, coming out of the house with a box, and that multiple doors and a television in Miss Lane's home were damaged. He identified the defendant in court. He explained he knew the defendant. The person at the house, the person at the gas station, the person in Miss Purdue's car were all the same person because of his clothing. And in light of this proof, there is no instructional error here that could have affected the verdict. Unless this court has any further questions, the state asks this court to affirm. Thank you.
Thank you, ma'am. Mr. Isaacs, I think you have about 3 minutes left. All right, Madam Clerk? 4 minutes.
May it please the court, in answer to your question, Judge Ward, Volume 1, page 95, lines 15 to 16, where we objected to Officer Thomas's testimony in its entirety and had out a jury hearing on that. In terms of the Judge Easter, did Mr. Arms identify him at the scene? He did show up, and we have cited the provision in our brief, and makes the comment, I think that's him. He also had made some comments that I'm going to touch on briefly, the sufficiency of the evidence argument, that he had seen a man with tattoos walking up and down the road frequently in the neighborhood. That's significant. Ms. Purdue said they did not live in that neighborhood, did not reside, had no reason to frequently walk around the neighborhood. But here's the sufficiency argument. So to believe in the light most favorable to the state, could a reasonable juror return a verdict of guilty on counts 1 and 2? To believe Mr. Arms, who saw this individual 200 feet away through a canopy of trees, he has a box full of stolen property, walks, didn't run, didn't secret himself, walked around the corner of the house immediately, which opens to the Raceway Market. There was no box found at any point in time. There was conjecture and speculation from Mr. Arms that a box had been placed in the black truck that had been lingering around the neighborhood. Based on our investigation and the proof at trial, the black truck belonged to a reserve officer from Anderson County who allowed Mr. Newman to use his phone, which in turn corroborated Ms. Perdue's testimony that they were there because of the Google app Find My Phone searching in the area.
Let me interrupt you just a second. I'm trying to remember the record, and we've had so many cases I may have misremembered, but did your client testify?
My client did not testify.
Did your client make a statement to the police?
Nothing, I don't think of significance. There was
Well,
the body cam.
did I read in the record that there was a body camera of the arresting officer and that your client admitted he was on the property?
There was a number, the body cam footage was from Officer Sweeten, which was an Oak Ridge police officer that showed up, and there were a number of statements that were unclear. I can't specifically recall, Judge Ward, him admitting to being in the property. I believe he admitted to being in the area looking for his phone.
My notes say that he admitted he was on victim's property but did not actually enter the house. Now, and I don't know where, I may have misread that. We've had 15, 14 cases here, so I may have misread that. But that would be significant in an argument that this identification was unreliable. If your client did in fact admit being on the property.
I would agree that it would be significant.
And I don't know if that's, we'll search the record and see if, I may have made that up out of thin air, and if I did, I apologize.
I will defer to your recollection and your comments. But again, there was not a scintilla of evidence that links Mr. Newman to the crime. And if you believe, there's as much evidence linking the man in the black truck, which is a security guard that worked for the Oak Ridge Police Department, as there is Mr. Newman, because he was supposed to be the person where Mr. Newman was handing off the black box. But it's important, and why this is so significant for the sufficiency argument, the fact that he borrowed Mr. Lindsay's phone completely corroborates Ms. Perdue, and it corroborates why Mr. Newman was there. Other than the glass shards that we've talked about, there was not a scintilla of evidence. And if you look at the eyewitness identification, a man with tattoos had walked around the neighborhood frequently. A black truck had been there frequently. It is our position that the identification was tainted. Mr. Arms also said there were two men that left the property. So respectfully, we would ask that the court reverse it on the sufficiency issue. The flight issue, we think, is extraordinarily significant because there was no conduct in the record that they fled from law enforcement, that they sought to hide, secret themselves, or leave the community. Thank you for your time.
Thank you. Does that conclude the docket, Madam Clerk? All right. We've had a good couple days here in Knoxville. Thank you all for your good arguments, good briefs. And we will be issuing our opinions forthwith. Greystone, any comments, Judge?
No, sir.
Anything?
No.
Thank you again, Judge Ward, for sitting with us